petition is about 78 acres of land, my lords, in Whitefield, which is in Bangalore. Broadly, my lords, valued in about 5,000 crores. This land, my lords, was allotted by the KIADB on a lease cum sale basis to the respondent number 2.
You are Mr. Which matter? Which
My lords, I am appearing, my lords, for Manu Prabhakar Kulkarni in item number 10. There is, my lords, a connected matter, my lords, in 10.1.
In both appeals you are appearing?
But I appear in the connected. Yes, we are appearing together.
Kumar appears in 10.1.
I appear for respondent number 2, my lord, in both the appeals.
My lords, may I?
So if you see the cost cycle, you will know.
Now, who is the appellant?
The appellant, my lords, is a person claiming to be a shareholder in the second respondent, who, my lords, is the allottee of the land. The appellant has filed a suit, my lords, for a declaration of title vis-a-vis his shareholding. That suit is pending, my lords. None of that dispute is being, my lords, agitated in the writ petition. In fact, I had paid money for 50% of the shares in the second respondent, who has got the allotment of 70 acres from KIADB. Inter se between me and the shareholder who is in control, there is a civil suit pending. KIADB, my lords, in fact, as my pleadings indicate, my lords, KIADB's pleadings are also available, my lords, in one other suit. I will place that before your lordships. The writ petition is filed, my lords, only vis-a-vis impingement of some of the conditions of the allotment of land between the KIADB and the second respondent company. In 2 minutes, I'll place the facts, my lords, before your lordship looks at any papers.
Yes. Yes.
The dispute was fairly simple, my lords. Whether I was right or wrong, I filed a writ petition bringing to the notice of the High Court that 8 charges are created on this public property and about 1,000 crores of debt are raised on this public property, and KIADB has not issued NOCs for 8 out of the 10 debts. Therefore, we indicated that without the NOC of the KIADB, how is a public asset being mortgaged to private banks and money being taken away by a private entity? My locus was raised, my lords, as an objection in that writ petition. The learned single judge, my lords, when admitting the petition and then considering it, held that given the gravity of the matter that is brought before court, my locus pales into insignificance, and therefore, my lords, issued a direction that there must be, my lords, an investigation conducted by the KIADB, and KIADB, my lords, must indicate what is the outcome. That was, my lords, brought up in appeal before your lordships. In fact, before a bench of my lord the Chief Justice in a different combination. My lord the Chief Justice, my lords, considered the appeal which was filed by the private petitioner, who, my lords, was the allottee. And my lords, continued to hold that KDB should conduct an inquiry, but did not issue a mandamus because KDB undertook that it is conducting an inquiry. Therefore, my lords directed that in the light of the undertaking, a mandamus is not necessary. As regards my locus, my lords, to file a writ petition, my lord, the Chief Justice, in a different combination, did not, my lords, observe that I have no locus. If I had no locus, my lords, the writ appeal should have been allowed and the writ petition should have been dismissed. In fact, my lord said that because I am a private party, I don't have to participate in the KDB inquiry. Let KDB inquire against the LOT. I had no objections to it. My lords also reserved all our rights, my lords, subsequent to that inquiry. The matter went back, my lords, to the KDB. Before the KDB, my lords, a section 34.1, 34.2 and a 34.3 notice was issued. In the 34.1 notice, about multiple violations were identified. Two of the violations predominantly were that one, you have changed the shareholding of the company. Please leave it aside. But primary violation is you have created 8 charges. I, KDB, have issued NOC only for 2 charges. You have to therefore make good that violation. After holding an inquiry, my lords, KDB reserves this matter for orders, my lords, in March of 2024. And on 3rd of September 2024, pronounces, my lords, a cryptic 1-paragraph order in which the order says, I, KDB, I am now giving you the LOT a further period of 2 years to develop the property. And my lords, thereafter adds reasons to that order. A span of, my lords, 7 days thereafter, on 10/7/2024, in the reasons, my lords, they simply turn up and say that there are 8 charges. I have only given NOC to 2 charges. About 1,000 crores is taken as debt. But because you, the LOT, you are now telling me that you will use this money for development and you have undertaken the task of clearing the property and appointing a security guard there. I am condoning, not even condoning it, I am simply giving you 2 more years. My lords, when that order was passed by the KDB, I, my lords, go back to the single judge, my lords, by virtue of a writ petition, saying that the KDB has done nothing except to parrot the observations and, my lords, simply by an order condone. That order, my lords, is a cryptic order. Reasons are attributed 7 days thereafter, which is impermissible. Therefore, illegalities are writ large. The learned single judge, my lords, dismissed my writ petition not on the merits of whether KDB is right. The learned single judge simply says, you, Mr. Puvaya, you had filed a writ petition that went up in writ appeal. Your locus was protected in the writ petition, but the writ appellate court has held that you don't have locus. Therefore, in the light of the observation of the writ appellate court, you are now divested of locus and therefore your writ petition is not maintainable. My lords, I am simply on appeal over that order, my lords. If my locus was right for the first writ petition and for the writ appeal before my lords, it couldn't be, my lords, that my locus is divested for the second writ petition where I challenge the order on merits. And permit me to show. I'm sorry.
Project is being developed by you.
Yes, my lord. I'll
Project
give you
is
a lordship
developed
the
by
facts.
Mr. Raghavan,
After
Mr.
my learned friend has finished, I will show to your lordships the findings accorded by the learned single judge.
No,
This,
the order only provides for extension of.
yes, and the appellant before your lordships, my learned friend started by saying, your lordship asked my learned friend a question. Who are you? And my learned friend said, my lord, I am a shareholder. That is a wrong statement.
I am a disputed
I'm
shareholder
sorry.
in suit.
They are not even shareholders.
My lords, I'll clarify that, my lords. Let me present my case.
Of course, you will. I'm not saying no.
My lords, therefore, please, my lords, permit me to show 2 directions of the learned single judge. My lord's direction in the writ appeal proceedings and my lords, the final finding in the impugned order, my lords, against me.
One second.
Can we refer this matter to mediation? You both can you settle down?
My lord, I have to take
I think
instructions.
take a try.
I have to take instructions, my lord, on whether the shareholders dispute can be resolved. In fact,
Mr.
I was
Poya, in the
given-
larger interest, both of you can settle, I suppose.
My lords, I am most willing, my lords.
I'm sorry.
My lords, may I make? I'm sorry.
My lord, I tell you, lordships, my lord,
Sorry.
what happened was
May I just
the-
make one statement, sir, with Mr. Raghavan's permission, my lords? I'm sorry, I have this problem of being remote. Please pardon me, my lords, on this.
My lord, no, my lord. I understand, my lord.
I just make one submission.
It is Monday, my lord, and we don't expect my learned friend to be here.
My lord, the
I
only
did
My
not
lord,
want-
my lord, I must say, my lord, I have a vested interest in my learned friend's prosperity, my lord.
No, I did not want to
And-
pull my learned
and-
friend's leg because
and-
I'm on the same side, but
And we are very proud of the fact, my lord, that he is in so much of demand in Delhi.
My lords, I'm grateful. We all learned the law, my lords, at Mr. Raghavan.
we were just asking that which is the essence of, what is the essence of the?
The essence of the dispute is he claims, my lord, in 2010, no? In 2006, he says that there was an oral agreement to convey certain shares in my company by the erstwhile shareholders to him. And therefore, today, the sale of the shares by those erstwhile shareholders in favor of somebody else was wrong. And he files a suit, my lord, not for specific performance. He files a suit for declaration. And in that, my lord, he sought for an injunction, saying that nothing must be done with respect to these shares. Injunction was refused. Matter was carried up in appeal before this court. Appeal dismissed in the commercial side.
The court said.
my learned
You should-
esteemed friend may not be entirely
His
correct.
lordship
He may
asked-
not be entirely correct. I'll point it out.
1 minute, 1 minute. Let me, his lordship ask,
He'll-
let me
he'll-
answer. I may be
Please
wrong,
point
you can
out,
correct
please
me.
The order says that subject to withdrawal of that suit. Is it? The order which was under challenge in the writ petition. Plan subject to withdrawal
Oh,
of.
no, I'm sorry. That's a separate
No,
suit.
my lord, that's
That
a
was a
separate
suit
suit.
filed by them against KAD.
No, my lord. What happened?
I'll clarify that, my
The
lords.
commercial
Yeah.
suit has been filed, which is pending. He claims, my lord, to be not a shareholder, to be an oral agreement holder with respect to sale of certain shares by erstwhile shareholders who have already sold the shares. They have gone, they have taken the money, everything is over. Now, my lord, because he filed an application for injunction.
Factum of oral agreement is admitted fact.
My lord,
Factum of oral agreement.
which agreement, my lord? No, seriously disputed. We said the oral agreement, nothing was there. And what happened, my lord, is this. Of course, my lord, is here. And he,
See,
well,
with all due respect,
my lord,
see, dispute between two private individuals, you have dragged the state authorities.
I didn't, my lord, there.
Whatever. It can only result in loss to both of you. I think if better sense prevails between you both, it is better to go to mediation, settle the matter. You both know what is the reality. It's after all a financial transaction. Be true to yourself and settle the transaction. I think that will all your disputes, because I can see multiple disputes over here, subject to you people.
I will take instructions, my lord. I'm not able to
But
say right away because, my lord, there is a commercial suit.
No, my lords, may I
have
just,
filed.
Mr. Raghavan may
Injunction
permit me.
application dismissed. They filed a commercial appeal dismissed. Then writ petition was filed. First time, my lord, an order was passed in the writ petition by the learned single judge in the earlier round. Writ appeal filed, order modified. Then, my lord, second writ petition now filed.
My lord,
And now, my lord, we are before your lordships.
my esteemed senior
Let's
friend
see
got a
if-
little carried away, not entirely correct.
Let's
Let me
see
point
if
out.
petitioner, are you agreeable for mediation?
My lord, mediation in principle, I'll never say no to, but that's besides the point. Let me just clarify a few facts. I have in fact asserted.
If you are agreeing for mediation, there is no point in hearing the matter.
It is an objective way to look at the controversy, to refer it to mediation, subject to you.
Lord, we are agreeable, my lord, for
My lords,
mediation.
please give me 30 seconds. I'm upfront, I'm indicating I'm agreeable for mediation. Please give me 30 seconds, my lords, to dispel this whole prejudice that has been, my lords,
Yes.
attempted to be caused. In 2006, my lords, I pay 9.5 crores.
Take instructions.
That money is received by my lords. My lords, I'll be candid. In fact, my lord, Justice Arun, my lords, will even recognize these are large builders in the city, my lords. I'll be in call candor, I'll place the facts. There is a Reddy Veerana and a Jitu Virvani fighting over, my lords, rights.
We don't look at the parties, Mr.
No, my
Commissioner.
lords, no, these are developers, my lords. That's what I'm just saying, my lords. Therefore, there is nothing to hide, my
The
lords. I've come in.
reference of a large builder is thoroughly irrelevant.